Hi everyone, a very warm welcome to thorough newspaper analysis for the 25th of April 2024. Now let's quickly proceed and have a look at the pointers of discussion for today. So in the editorial segment, we've taken up an Indian Express article, and this article is a follow-up article on the ban that was imposed by Karnataka government on hookah smoking. The matter in our previous story, we discussed how there was a notification by the government banning such sort of an activity, and therefore the hookah bar owners and others, the other stakeholders in this business, they approached the High Court. So the matter was before the High Court, and now the High Court's judgment has been delivered. So we'll have a look at what the High Court has said, whether it is upheld or whether it has curbed down the ban, or if it has upheld, then what are the grounds for that. And primarily in this article, what you can take back home is how a directive principle of state policy is unfolding, how the government is giving effect to a DPSP. So the title of this article is Why High Court Upheld Karnataka's Ban on Hookah. Secondly, we talk about news updates for the day. And this is going to be followed by the last segment of legal news, where we have two updates from the Honorable Supreme Court. So now let's start with the article, and let's start the article with its title, Why High Court Upheld Karnataka's Ban on Hookah. Now, before we get into the why of it, let's see the notification impugned before the High Court, which created this entire stir. So, see, essentially on 11th of February, there was a notification which came from the state government in the state of Karnataka. This notification essentially banned the sale, then, your consumption, storage, advertisement, and promotion of all types of hookah products within the state of Karnataka. So then, because, it sort of imposed a ban on hookah bars, so therefore, those people who were in the business of, this particular activity, they felt aggrieved, and they also wanted to, sort of claim their right to practice any profession, carry on any trade or business. So they approached the Honorable High Court of Karnataka with the same plea. Now, the Karnataka High Court has responded with this verdict. So now let's see the context. The Karnataka High Court on Monday, which was 22nd of April, it upheld the state government's ban on hookah smoking as being in the public interest, or in being in the interest of the general public. And the High Court ruled that hookah bars, they were an illegal service under India's anti-tobacco law. So what we can gather from this particular para is that this ban was upheld by the High Court primarily on the ground and consideration that the interest of general public was harmed because of this particular activity of smoking hookah. And secondly, the court said that hookah bars, they were not merely, an activity of, let's say, somebody smoking a cigarette in a designated area. It is different from that, and therefore it is an illegal service, and it is a violation of the anti-tobacco law that we have in place. So on 11th of March, a single judge bench of the High Court, it had reserved its judgment on the challenges by several resto owners to the government's 7th February notification. I'm sorry, this is not 11th February, this is 7th February. You can correct this. All right, so now let's talk about the consideration of directive principle of state policy and the fundamental right to carry on any business or any trade, commerce, occupation, which is the domain of Article 19. And the DPSP concerned here is Article 47. So how the court sort of, balance these two conflicting interests? Let's see that. The government argued that Article 47 of the Indian Constitution, it places a duty on the state. Now, what is that duty on the state? It asks the state to raise the level of nutrition and the standard of living and to improve public health. And it also includes the prohibition of the consumption, except for medical purposes, of any intoxicating drink or of drugs which are injurious to public health. As I've already mentioned, Article 47, it is, along with other provisions in Part 4, a directive principle of state policy. And we also know that a DPSP, or a directive state of policy, directive principle of state policy, it is not enforceable by any law. It is non-justiciable. However, it does not mean that it does not carry any value at all. It is, in fact, a very prominent sort of legal instructions, constitutional instructions rather, to the state government. So then what is its purpose if it is not enforceable by court? See, the principles which are contained in part 4, they are nevertheless fundamental in the governance of our country, and it shall be the duty of the state that the state applies all of these principles wherever needed and practiced, while making laws, while taking any policy decision. So the High Court held that Article 47, it was intrinsically linked with the right to live with dignity, which is a part of Article 21. So the court established a correlationship between Article 47 and the fundamental right to have a life where there is dignity. So to live a life which is filled with dignity, which is a part of Article 21, and the court established a link between these two articles. So now let's see what the court had to say on the interplay of these two articles. So the court said that the paramount duty is cast upon the states and its authorities to achieve appropriate level of protection to human life and health, which is a fundamental right which is guaranteed to the citizens under Article 21. The petitioners argued that the government's notification, it violates the fundamental right to practice any profession or to carry on any occupation, trade, or business, which is guaranteed by Article 19, Clause 1, Subclause G. So this was the petitioner's argument to rebut the state's claim by saying that, I have a right to practice any profession that I choose to, or to carry on any occupation, trade, or business. And it is my fundamental right, which is guaranteed under Article 19, Clause 1, Subclause G. But the court had something else to say. So the court, however, said or held that this fundamental freedom under Article 19, it can be subjected to certain reasonable restrictions. And what is the reasonable restriction that is attracted in this particular case? By now, you must have guessed it also, because here the interest of general public was the utmost, consideration. So similarly, the court said that it is subject to certain reasonable restrictions, including the prohibition of certain occupations, trades, and businesses, if it is in the interest of the general public. So if the prohibition of any business, occupation, or trade, it is in the interest of the general public, then that can be done. The court also held that directive principles such as Article 47, it can be used to justify a restriction on citizens' right under Article 19, Clause 1, Subclause G. Now let's talk about the discussion before the court around whether, the smoking of hookah, it tantamounts to rendering a service. And if it is equivalent to rendering a service, then would that be within the domain of illegal service under the 2013 Act, which is the Cigarette and Other Tobacco Products Prohibition of Advertisement and Regulation of Trade and Commerce, Production, Supply, and Distribution Act. Let's see. See, there is a section in this 2003 Act, which is section number 31. So under this section, the center, it can make further rules to carry out the provisions of this particular act. So let's say there are certain provisions of this particular act, and if the center wants to carry out those provisions, then it can prescribe certain rules to implement these provisions in practicality. So in 2008, the prohibition of smoking in public places rules, they were brought into effect to carry out the mandate of this particular act. Now, the single judge bench of the High Court relied on a rule, which is Rule 4, Subrule 3 of these rules, which after an amendment in 2017 states that no service shall be allowed in any smoking area or space which is provided for smoking. So basically, there is a rule in these rules, which is Rule 4, Subrule 3. And this rule was amended in 2017. Now, the current position is that by virtue of this rule, if there is any, let's say, area which is designated for smoking, so no service can be provided for facilitating this smoking in this designated area. So the court asked whether hookah smoking, it is plain smoking which can be permitted in a designated area, or is it a product of service that needs to be rendered. So let's take an example. If somebody were to smoke a cigarette, then the person does not need any sort of an apparatus, right? You just need to have the product that you're smoking, and then you can go to the designated area and carry on the activity of smoking. But when it comes to hookah smoking, then you need a legit apparatus. For example, these sort of equipments, and these apparatus and the other whatever other things that are needed for the smoking, they are to be provided, they are to be established in a certain area. So therefore it is not just a matter of, let's say, somebody just taking out a cigarette from the pocket and smoking. This rather amounts to rendering a service. This is in fact what the court said, that to answer this particular question, which is whether it is a plain activity of plain smoking or does it amount to rendering service, to answer this question, the court compared hookah smoking to smoking a cigarette and then distinguished these two. So the court found that while smoking zones created in designated places do not give any other service except creating a smoking zone. So let's say for somebody who is smoking a cigarette in a designated area, there no other service apart from marking that area as a designated smoking place is rendered. No other service is rendered. But when it comes to hookah smoking, it needs rendering of services in the designated areas, as it requires external human hand to place all the apparatus, all the equipments on the tables, like food or alcohol would be served on those tables. So just like service of food and serving of alcohol is done in a couple of bars or dining places, so similarly for hookah smoking you need to render an external human hand and provide services. Thus the court held the very act of preparation to smoke hookah tobacco cannot but be held to be a service, and the state is only implementing a prohibition against service that is already in place. The court held that the notification would also apply to herbal hookah, which too require an instrument and thus qualifies as a service under the rules. Because one of the petitioners, he argued that his product is herbal hookah, so it does not pose any sort of threat to the public health, and therefore he claimed protection, or he sought to be distinguished from the others in the domain. But the court said that no, you are also covered rightly here, because in your service also you need an instrument and an apparatus and an external human hand. So now with this, we proceed to the next category of national news for today. Indian Navy women officers, they complete historic Transoceanic expedition. Lieutenant Commander Dilna K and Lieutenant Commander Rupa A, two women officers of the Indian Navy, they've created history by successfully completing a nearly 2-month Transoceanic expedition on the Indian Navy sailing vessel, which is the INSV, called Tarini. They are the first women from our country to achieve this remarkable feat. This expedition, it flagged off from Goa in February, on the last day of February, and then it concluded with its return to the base port on 21st of April. Let's talk about some of the highlights of the expedition. So both of these officers of the Indian Navy, they navigated the Indian Ocean for about 22 days, and then they reached Mauritius in March, later days of March. In Mauritius, they interacted with the officials of their Coast Guard and the Indian High Commission, thereby strengthening the bilateral ties between the two maritime nations. Thereafter, some training sortie with the Mauritian Coast Guard, it was also conducted, apart from other activities that were carried on during this expedition. So for the purpose of our exam, what we just need to note is the names of both of these naval officers and maybe the sailing vessel that is involved here, which is Tarini. India successfully tests Crystal Maze 2 missile. The Indian Air Force, it aims to obtain Israeli missiles in bulk through Make in India for their special capabilities. The Indian Air Force, it tested the ROX missile, which are capable of striking targets of nearly 250 kilometers away. So the range is 250 kilometers, which is they are targeting and seeking to strike, marking a major capability enhancement. Conducted in the Andaman and Nicobar Islands, the successful test, it showed the air-launched ballistic missiles potential originating from Israel as the Crystal Maze 2. Next up is another update with respect to personalities domain. Sudhir Kakar, who is called the father of Indian psychoanalysis, he dies or he has passed away. Sudhir Kakar, who is often hailed or termed for his recognized for his originality and insight into the Indian psyche, has recently passed away at the age of 86. Top Royal Honor for British Indian Medic. This is an update in the category of awards. Britain's King Charles III, he has unveiled a set of top royal honors, elevating senior British Indian medic Lord Ajay Kumar Kakar and musician Lord Andrew Lloyd Webber as his new knight companions of the most noble order of Garter. See, essentially here, what you have to note for the purpose of your exams is the name of both of these personalities and the honor, the royal honor that has been bestowed upon them, and the person concerned who did the unveiling of these honors upon these two persons. Next up is an update in the segment of culture, tradition, that sort of a domain. So, largest temple festival, Thrissur Pooram 2024 in Kerala. This festival, essentially, we have to note down 2-3 pointers from this news update. One is that this is a festival which is called Thrissur Pooram. It is a grand temple festival which is celebrated in the South Indian state of Kerala. And this is deeply rooted and predominantly rooted in the Hindu tradition. But this 7-day festival, it sees the gathering of people from all walks of lives. So what we need to understand for exam purpose is mark the name of this festival, then the state concerned, which is Kerala, and then it is deeply rooted in the Hindu tradition and the Hindu community. Next up is an update in the category of books and authors. Boria Mazumdar, he launches his new book, which is called Banned, a Social Media Trial. See, this book has an interesting background to it. So let's talk about who is this person, then, what is the background of writing this book and what is this book about. So Mr. Mazumdar, he is a well-known sports journalist. He was handed out a 2-year ban by the BCCI, which is the Board of Control for Cricket in India. And why this ban? The Indian Cricket Board had issued this ban upon him following allegations of threat and intimidation from one of India's wicket-keeper batters, who said that after he reportedly declined an interview request from the author, he was intimidated and threatened. So therefore, the BCCI imposed a 2-year ban upon him. So now he has launched his book, which is called Banned, a Social Media Trial, in which he talks about how he faced a social media trial following a cricketer's allegation and how it impacted his personal as well as his professional life. India calls for regional observation center at the 2024 Ocean Decade Conference. India, which was led by the Earth Sciences Secretary M. Ravichandran, it advocated for the establishment of a region-specific ocean observation center. And where was this need advocated or this update highlighted? So this was done by the Indian delegate during the 2024 Ocean Decade Conference, which was held in Barcelona in Spain. This conference, it is organized by the Spanish government and UNESCO's Intergovernmental Oceanographic Commission. It is aimed at assessing progress towards the goals of the United Nations Decade of Ocean Science for Sustainable Development and to foster collaboration among the various stakeholders. Next up is an update in the category of important days. So we talk about the National Panchayati Raj Day. The National Panchayati Raj Day, please remember, it is very, very important. It is celebrated, observed, marked every year on 24th of April. And while the celebrations are, carried on, there are certain panchayats which are nominated by the states governments, by the state governments and the union territory administrators and administrations. They are awarded. They are given, awards in several categories. So what are some of the categories of awards? Let's talk about that. So first is Deen Dayal Upadhyay Panchayat Sashактikaran Purushkar. Sashактikaran essentially means empowerment. So it is Deen Dayal Upadhyay Panchayat Sashактikaran Purushkar. Second is Nanaji Deshmukh Rashtriya Gaurav Gram Sabha Purushkar. Third award is the Gram Panchayat Development Plan Award. And the last being Child Friendly Gram Panchayat Award. So those Gram Panchayats which are nominated by the concerned state governments and the UT administrations, they are then, shortlisted, looked at, scrutinized, and then eventually awarded. Now we proceed with the legal news updates for the day, starting with the Supreme Court update. So here essentially, I'll give you a crux of it and then we get into the reading of this update. See, Supreme Court has essentially said that if any High Court wants to, procure the presence of any public servant, any public government officer, then there is a procedure to it. The High Court first has to make sure that there are reasons which justify the calling of a government officer before the High Court. And if there are necessary reasons for that, then first you arrange a video conferencing and talk to the person concerned via video conferencing, and thereafter you can maybe take recourse to the physical presence. So here, deprecating the practice of high courts routinely directing the personal appearance of government officers, the Supreme Court has held that if the High Court found it necessary to direct the presence of the government officer, then it should have been first done through a video conferencing. In this regard, the court referred to the SOP. SOP, stands for the Standard Operating Procedure. So there is an SOP in this regard, which was laid down in the case of State of Uttar Pradesh and others versus Association of Retired Supreme Court and High Court Judges at Allahabad and others. In this particular case, an SOP was laid down on how to secure the presence of, let's say, a government officer. And here, the bench comprising Justices B.R. Gavai and Sandeep Mehta stated that it is specifically provided in this SOP that in exceptional cases, if the High Court finds that the presence of a government officer is necessary, in exceptional cases when it finds that, it is necessary, then at the first instance, such presence and appearance, it is permitted through video conferencing. So therefore, the court said that we further find that the reasons that, so this is with respect to the particular case. So what it essentially had happened was the Calcutta High Court issued an order which directed the personal appearance of the jurisdictional SP before itself without recording the necessary reasons for calling out such personal appearance and presence. So therefore, the Supreme Court said in this behalf that we further find that the reasons recorded by the High Court for directing such personal presence of this jurisdictional SP, it cannot be said to be exceptional or rare. So this was a fact finding. For our purpose, we just need to note this legal position. So the name of this case is the State of West Bengal versus Ganesh Roy. Another update from the Honorable Supreme Court itself. So the Supreme Court has observed that subject to statutory stipulation, that is to say, subject to any provision in any statute that is made, this is the general rule. What is the general rule? That a repealed provision, it ceases to operate from the date of its repeal. So suppose, let's say there is the CRPC presently, which is the CRPC of 1973, right? But we had an earlier CRPC as well, which was the CRPC of 1898. So when the new CRPC came into picture, the old one was repealed, correct? So the Supreme Court has said that a repealed provision, or let's say a provision which is repealed or any particular entire act which is repealed, it ceases to operate from the date of its repeal. And the substituted provision, it starts operating as and when it is substituted. So the moment the earlier code or the earlier provision, it is repealed and it is substituted by another one, then the date of repeal, on that date, the earlier provision, it ceases to operate and the substituted one comes into picture. But this is subject to any provision made in the statute itself. So the Supreme Court observed that the operation of repeal or substitution of a statutory provision, it is thus clear. A repealed provision will cease to operate from the date of its repeal, and the substituted provision, it will commence to operate from the date of its substitution. This principle, however, the court highlighted, it is subject to specific statutory prescription. So to give you an example, I believe if you have a look at section 484, which is the last section in the current CRPC of 1973, there you'll see that it has specifically said that, if there is any order of proclamation of or any other order that is being made, then for that the provisions of the old CRPC would be carried on. But when there is any application, appeal, or all of these proceedings which are pending immediately before the repeal of the old act, then the new provision will apply. So what has happened by virtue of section 484? It is said that the old act, it is repealed hereby and the new act comes into picture, but for so and so situations, the old act will be continued for, let's say, this particular application, this particular order which was made immediately before, the old act will be carried on. So it is specifically stated in that section. So similarly, the court said that this principle is subject to specific statutory prescription. Statute can enable the repealed provision to continue to apply to transactions that have commenced before the repeal. Similarly, a substituted provision which operates prospectively, if it affects the vested right, then it can also be directed to operate retrospectively by the statutory prescriptions. The name of this particular case is Pranod Richard India Private Limited versus the state of Madhya Pradesh. And this has brought us to an end of our TNA. Thank you for being with us. Have a wonderful day ahead.